I'd like to share with you this morning one piece of a larger research project that examines the normative dimensions of sex segregation. Questions about the legitimate scope of sex segregation increasingly employ democratic legal systems worldwide. So, for example, UK authorities debate the legality of Jewish and Muslim schools offering different curricula to boys and girls. In the US, divided buses in lines serving the Brooklyn Hasidic community, separate swimming hours for men and women in a New Jersey condominium to accommodate the Orthodox Jews, or women-only gym spaces have reached policymakers and courts. In India, a ban on women from entering a mosque was adjudicated by India's Supreme Court. I'm focusing on Israel as my case study, not just because I know it most closely, but because in the past decade, it's been a highly dynamic and rich social legal arena, providing an opportunity for a complex analysis, which I'm happy to say is drawing many brilliant Israeli minds and legal minds. Many of them are part of this conference today, including Barak Medina, Manny Mautner, Neta Barak-Koren, and soon also hopefully Rawi Abu Rabia. I will start by a brief background on sex segregation in Israel and then move to my analysis, which I warn you, it's not for the faint of heart. It takes a bit of a stamina ideologically, but I'll divide it into two parts. In the first that I will describe more elaborately, I'll offer thoughts about why it is that for many, segregation based on sex is not the same as segregation based on race. In the second part, which I'll only have time to outline briefly, I will maintain that despite the differences I mapped, in fact, in their actual manifestations, in the phenomenology of sex and race segregation, or in the in vivo social behavior, these types of segregation are more similar to one another than initially meets the eye. So, some background. Sex segregation in Israel has been expanding in the past decade to growing spheres of life and activities. Justified as accommodation, essential for encouraging the economic participation of the ultra-Orthodox or Haredim in the employment and consumption markets, in higher education, etc. It's also justified as derived from a multicultural imperative of liberal societies to tolerate illiberal practices. So we've been witnessing in Israel the institutionalization and normalization of segregation in diverse contexts, as I said, academic studies, professional training, bus lines in Haredi areas, public events, entertainment parks, the military, and more. The American case of race segregation, of course, looms large over the Israeli debates about the legitimate scope of segregation. The 1954 seminal Brown versus Board of Education is often invoked as a point of reference in these debates. For some, this is a focal point to mark that the wrongness in segregation is not asymmetrical conditions allotted to whites and blacks, but that even when the separate are equal, as the US Supreme Court said, the very practice of socially distinguishing between blacks and whites is based on arbitrary and unjustified reliance on racial differences. Hence, it is wrongful discrimination. Others, however, feel that sex is not like race, and hence that Brown cannot be simply applied to the current dilemma faced in Israeli society. Israel's case law of the past decade has demonstrated similar ambivalence. While it is quick to strike down segregation practices that provide women with inferior conditions, either less physical space, less budgets, etc., It is less resolute about the nature of the wrong associated with sending men and women to different classrooms or in offering them different hours in the public library. Take, for example, a municipality that funds a concert catering to the ultra-Orthodox audience with sitting areas that are divided by sex. Such a concert in a northern township in Israel called Afula in 2019 drew a heated public debate due to a petition by an NGO, Israel's Women Network, arguing that for the city to design a public space when sex becomes a relevant fact in the sitting arrangements is ultra vires, illegal discrimination. Many commentators around this issue felt that unlike racially segregated concerts, such a sex-segregated event could pass muster if men and women were to be seated in similar distance from the stage, admissions fare were identical, and all other conditions were symmetrical. Under such conditions, there would be no harm in accommodating preferences for separate seating. Others suggested that even if there were discriminatory effects to segregation, such effects would be segregation in itself, symmetrical segregation. Such effects would be cured if, in addition to a male section and a female section, there would be an area for mixed seating. Again, the question I'm interested in is why this solution seems appealing or plausible, while clearly it would not appease our concern in a parallel situation of race. Had we offered a mixed seating area but blacks here and whites here, we would still feel that this is intolerable. So this normative sense of puzzle and indeterminacy was evident in the adjudication of the case, the Afula case as well, when one district judge sided with the petitioners and another sided with the township. So far I've mentioned two components or indicators raised in the normative analysis of sex segregation. Symmetry is one, and what's the other one? Choice. So the fact that people can choose a mixed seating. There is more to be said about voluntariness, which I will leave aside for now. I'll also now talk about two other important components of the issue, which are the multicultural dimension in the Israeli circumstances, and also the question of humiliation. Some people, when they interpret Brown, they say, oh, Brown really said that only if you have clear indications that black kids were humiliated, only then separation is wrong. I don't think that's a right interpretation, but I'm happy to talk about those questions in the Q&A if we have time. So let me outline 5 explanations for the normative dualism by which sex segregation is not recognized as harmful to equality, liberty, and dignity as race segregation. This discussion is conceptual in nature. It's sort of a thought exercise grounded in history, culture, and politics of race and sex. So first, unlike race differences, sex differences are anchored in actual morphological and functional physical traits. Most gender egalitarian approaches do not deny that in some contexts, sex differences are more than a social construct. In contrast, there are very rare contexts in which racial differences can be argued to be based on anything beyond sociocultural classifications. Under the formula of substantive equality, by which equality requires taking differences into consideration when they're relevant, race is rarely ever considered a relevant factor for allocating rights or designing social spaces, but sex is still considered a significant trait in some contexts. Indeed, it took a while, but nowadays it is almost axiomatically accepted in liberal democracies that race is a construct, race is what race does, a social distinction that cannot serve as a proxy for capacities or determine life trajectories. Race is relevant as a category for social analysis that seeks to undo its misuses by recognizing and understanding the race-based biases and disparities, and by studying and appreciating its cultural and historical meaning. It of course is also relevant for affirmative action purposes, and in some very small medical contexts, like genetic contexts in which some races have illnesses that are genetically defined. In contrast with sex, the challenge of distinguishing between contexts in which sexual difference should be a factor in allocating rights and freedoms or in designing policies requires a much more nuanced analysis, because sexual differences, as I said, sometimes do have some anchoring in reality outside of their function as socio-legal constructs, most notably with productive functions and workplace anti-discrimination and accommodation rules. So to sum up this point, we're much less suspicious of sex differences than towards claim of race differences, because some differences between males and females are considered significant for how our institutions and opportunities are organized, which is not the case with racial differences. The second point is derived from the first. Our social arrangements are abundant with sex-segregated spaces that, at least until recently, were considered benign, unharmful to sex equality, such as public bathrooms, sports, or Oscar nominations for Best Actors. Today, awareness has been increased as to the ways in which these divisions reinforce essentialist binary notions of gender, failing to accommodate transgender people and others who do not conform to the conventional gender binary. For the present context, however, my point is that our eyes are accustomed to some instances in which spaces are or organizations divide people on the basis of sex, and in contrast, public bathrooms or Oscar nominations that would be divided on the basis of race would be point blank unacceptable. Third, while race segregation is experienced as humiliating, some contexts of sex segregation are perceived as serving women's will and interest, or at least as aligned with their worldview. Therefore, absolute condemnation of sex segregation risks insensitivity to women's experience of segregation or women-only spaces as validating or protective in some contexts, raising critiques that delegitimizing sex segregation would be paternalistic, patronizing, and expressing a rigid notion of formal equality. Sex segregation is a common practice among the Abrahamic religions, as we know, in various degrees. They're also familiar to us for many other contexts, car trains in several countries, rentable workspaces that are becoming popular, or women-only workspaces, etc. The fourth difference I want to mention is that with race, we're generally more willing to recognize the dimensions of power and dominance than with sex. Race relations have been theorized as oppressive, exploiting, dominant, typified by animosity, violence, stigma, and struggle over limited materials and symbolic resources. So when the Supreme Court says in Kuramatsu in World War II that there is a racial antagonism at the background of sending Asians to camps, the public gets it. They know what we're talking about. As opposed to sex, where it has been much harder to provide accounts of power and dominance. They have been provided, of course, but they're not as acceptable. We don't find case law that invokes the dominance relationship between men and women as the premise for the legal analysis. And we can remember from John Stuart Mill and probably also Harriet Taylor Mill, which wrote it with him, that with the difference of the subjection of women, unlike the subjection of races or classes, is that male power expects women not only to be slaves, but to be happy and willing slaves. The fifth and last point is perhaps the most important and kind of palpable one for understanding why race segregation draws harsher and more immediate moral and legal condemnation than sex segregation. And it is that we are less suspicious of sex distinctions because classifying human beings by their sex is the most fundamental classification we make about humans. Our language is intolerant in not making it. It's the first thing we ask a pregnant woman, or before ultrasound. It's the first thing that the nurse said. It's a boy, it's a girl. We cannot think of humans without it. Now, I don't have time to describe elaborately the next phase of this project, but I'll just say that this is a less conceptual and more historically grounded one in actual manifestations of race and sex segregation. And it demonstrates that notwithstanding the different rationales and values underscoring race or sex segregation, their distributive effects and their phenomenology are more similar than meets the eye. So, for example, what is presented as symmetrical segregation in both cases is more often than not actually discrimination. Another point is that the Brown court's understanding that the very making of racial difference is a significant social category is harmful, also works with signifying sex segregation in contexts where it's not relevant. Sex segregation is kind of taints and otherizes bodies in similar ways to race segregation. And finally, in both cases, segregation norms were created and preserved by one side of the binary, that is whites or males, and women and blacks had no voice in creating those norms. So these commonalities between race segregation and sex segregation provide, I maintain, hefty reasons to recognize the actual harms to equality and human dignity caused by sex segregation, as many democratic legal systems have identified regarding race segregation. Thank you very much.
Thank you, Yofi.